And please start.
Hmm. Good afternoon. We begin from where we left off in the last class. We had to start with acceptance of deposit. Today in this class, we are going to finish off with company law, as well as we are going to begin with contract law, Indian contract law. And if there's still time, we can talk about Negotiable Instruments Act as well. Acceptance of deposits by companies is a part of the debt capital that companies raise for themselves. When we look at the Companies Act, Section 2, subsection 31, it defines what a deposit is and how a deposit is to be treated. What exactly is the meaning of deposit and what are the implications of a deposit as such? Section 2, subsection 31 talks about a deposit in the sense that it is a debt capital. It usually is not a secured amount of money, which basically means that the company does not create any charge over any of its assets in favor of the deposit holders, the people who extend that deposit to the company. However, it is nonetheless an obligation of the company to return or repay that amount of money upon expiration of a certain amount of time. So basically, they talk about deposits as including any receipt of money by way of deposits or loan or in any other form by company, but does not include categories as may be prescribed in consultation with Reserve Bank. Now, the reason why they have Reserve Bank here, it is very important to note, is because taking deposits and lending money is primarily a banking business. Now, if you wanted to do banking business in India, you will have to take the license from the RBI in order to do that. You cannot, because it is such an accountable job where you are taking money from the depositors. Depositors don't have a say in the management of your company. What do you do with the deposits? How exactly will you raise it? Or how exactly are you going to repay it? So the depositors are in good faith belief that you will be repaying it upon a certain time or upon demand, usually. However, which basically happens with the banks. However, with this particular concept, where there is acceptance of deposits by companies, this is a concept which is only very peculiar to companies which are not banking companies. And which is why, if any other company, other than a banking company, if they want to seek deposits, they have to take the permission from the sectoral regulator, which is the RBI in this case. Now, coming down to Companies Acceptance of Deposit Rules 2014, this also defines what a deposit is, acceptance of deposit, and what sort of an amount would we consider as a deposit, even if it is being contributed by the central government or the state government, if it is contributed by any municipal bodies, local authorities, or statutory authorities, or anything which is received as foreign amounts of money. So you can have debt capital holders in a company which come from overseas. So you can receive money in foreign exchange, basically. So all of these under Rule 2C, they have mentioned who are the people who can be the contributors of this particular debt capital, which is deposits, which is an unsecured amount of money, and would make you, the deposit holder, the creditor of that particular company, which is seeking these deposits from you. So clearly, there would be an acknowledgement of the fact that you have paid a certain amount of money, and this is not on demand, which basically means that you can't issue a check and instruct the company to pay off the deposits which the company is holding with itself, which you have contributed. But the company only says that there would be a redemption period upon which we are going to repay this amount of money, principal along with interest, etc. So this is the whole concept of the deposit, acceptance of public deposits in companies. Now, who exactly is a depositor has also been discussed over here in the same rules. Either any member of the company who has made a deposit, or any person who has made a deposit with a public company. And this person would mean juristic person or legal person, either. So if you have any questions, do ask. And member of a particular company could be an individual member or could be a corporate member. Either ways, depending on who is the one who is paying the amount of money. So a member ideally in a company with a share capital would be a shareholder. So in addition to contributing to the share capital of the company, you're also contributing to the debt capital of the company, which makes you a depositor. Now, this rule also suggests as to what are the amounts of what are the companies which can actually seek that sort of a deposit. So, what is it that you can, which companies are the ones which can actually seek those deposits? What is the eligibility of these companies? How much should the net worth of these companies be? Or to what extent should it have, what sort of business should it have? Or what sort of limits that you can specify? So whenever a company see, this is a liability for a company. So clearly, if the company has to get these additional liabilities, all of these have to be passed by the general meeting, and the members have to ratify the fact that we are we are consenting to this proposition that money would be raised by means of deposits. Then there is this concept of prohibition on acceptance. So Section 73, subsection 1 of the Act says that new deposits would only be taken under the Companies Act of 2013. So if there were any deposits that the company has taken under the 1956 Act, they'd have to return it with immediate effect the moment the Act got repealed. So clearly, that particular prohibition would be for the companies which have sought deposits under the 1956 Act, which is no longer applicable. And clearly, this acceptance of deposit, which is applicable for a company, will not be applicable to a banking company or, for that matter, NBFCs. Non-banking financial corporations have their own way of functioning. There are like 11 or 12 kinds of NBFCs in India, actually. You have uh, microfinance institutions, you have deposit-taking NBFCs, you have NBFCs which are infrastructure leasing and finance companies. Then you have NBFCs which are asset finance like Muthoot Finance, etc. So, or you have all of these DHFL, which used to be the Diwan Housing Finance Limited. So there are many kinds of NBFCs that there are. So there can be deposits which can be sought by companies which have a deposit taking, which are of the nature of deposit taking NBFCs. So in such cases, if there is a deposit taking NBFC, that NBFC would now be considered as what do you say, as an NBFC which can solicit deposits under the permission of RBI. Also, clearly, if you wanted to have an NBFC for that matter, that particular NBFC would need to be registered not just with the Companies Act, but would also be requiring a license from the RBI under Section 45 IA. So the way NBFCs function is different from the way companies, which are not NBFCs or not banking companies, function. So in such cases, this section of Companies Act of seeking deposits, acceptance of public deposit, is not applicable either to banking companies or NBFCs because they have their own legislation, they have their own pieces of legislation which govern their deposit taking or their prudential norms, which are set by their sectoral regulators, etc. And obviously, there's an obligation to pay it back because if you do not pay these things back, then there becomes a problem. Then the particular, the what do you say, the uh, people who have given you the deposits, basically, they can actually be your unsecured creditors and they can come and seek for that amount of money from you. So in such cases, you are supposed to pay back, and if you fail to pay back, there's also a penalty under the Companies Act itself that the directors of such companies will then be liable, basically, for what do you say? Directors of the company would be liable for cancellation of DIN, basically. So that is under Section 149, etc., which talks about the disqualification aspects of a particular director. So whenever we talk about deposits, acceptance of deposit, there's a resolution that is passed in the general meeting, and thereby there's a consultation with the RBI, and eventually acceptance of deposits from its members is then sought, including the provision of security for the repayment of such deposits as may be agreed upon between the company and its members, subject to the fulfillment of the following conditions. So the fact that you are seeking deposits, I said that deposits is a liability. So at the very outset, as a company, what you need to furnish is the fact that there is a declaration of solvency. Do you have enough assets, or do you have enough scope, or do you have enough resources to pay back those deposits that you are seeking from various people? What exactly is the credibility of your company with respect to seeking these deposits? Have you defaulted in your previous deposit repayments, or have you been debarred from the capital markets because of some sort of a capital market fraud that your company has committed, or some such thing which is extremely damning for a particular company before it goes to seek those deposits? So all of these circular to its members, including a statement which shows all of these particulars about the company, as well as all of these compliances have to be fulfilled by the company before it can go to seek deposits. Now, acceptance of deposit from public by certain companies. Section 76 provides that nothing, notwithstanding anything in 73, the company may, if they have the kind of net worth and the turnover which has been prescribed, it may accept deposits from person other than its members, subject to compliance with the requirements under Section 73, subsection 2, and subject to such rules as the central government may, in consultation with RBI, prescribe. So such company shall be required to obtain the rating from a recognized rating agency, and eventually that particular company can then seek your deposits. And the rating shall be obtained every year. So you have credit rating agencies which actually rate out your credibility of repayments. Can you repay the amount of money? What exactly is it? How exactly do we assess the credibility of your company? So all of these things are something which is very important for your company to furnish before it could think of accepting public deposits. And clearly you need to repay. If you have taken the money before the commencement of the 2013 Act, you need to repay it immediately without having any regard to the amount of time that you have given for as a redemption period. You have to repay it immediately. But if it has been done under the 2013 Act, in such cases, that amount of money has to be paid with interest after that particular time that you have, in fact, stipulated within that deposit certificate which you have given. And clearly there's punishment. In addition to all of this, one of the biggest punishment is that the DIN of the directors may just get cancelled if they are found to be guilty and in connivance with the fact that the company has been unable to repay. Now, depository receipts are different over here. When we talk about depository receipts, they actually talk about when a company goes to raise capital from foreign stock exchanges. So if your company, say Reliance in India, if it is listed with the BSE or the NSE for that matter, they will actually be selling the shares of Reliance. However, if Reliance was to go to, say, New York Stock Exchange, then in such cases, in New York Stock Exchange or say in London Stock Exchange, wherever Reliance wants to get listed in, those places, Reliance would be selling their depository receipts and not shares as such. So, shares, scrips, bond, all of these things are not sold. What are sold are global depository receipts, or there's a concept of American depository receipts, or there's a concept of different kinds of depository receipts. Similarly, if there was a foreign company which came to India to get listed on one of its stock exchanges, either BSE or NSE, you're going to buy Indian depository receipts of those companies. So depository receipts are a way of possibly raising capital from foreign shores by getting listed and getting your shares traded on the foreign stock exchanges as such. And these are governed under the FEMA because clearly it is something that you are raising from foreign shores. And the second thing is, barring FEMA, we have this other concept of what do you say, foreign exchange, or how exactly, what is the route, or what exactly is it that you can do with respect to these companies which are trying to raise out capital from foreign shores through listing on other stock exchanges. Now, the company shall appoint all of these people because the idea is that the compliance of deposit receipts is much like a public offer, and it needs to have all of these people who are there to oversee all the compliances of this particular issue. So the entire rules, regulations are technically mentioned within these central legislations, which have been mentioned. And then you get voting rights also if you are a deposit receipt holder. Then you have the fact that how can you hold these deposit receipts and what. So there's literally no difference as such if you talk about a shareholder of a company or a person who's holding a deposit receipt of the company from a foreign stock exchange, because at the end of the day, if he has invested in a share capital of that particular company, you will also be considered as a shareholder of the company, and not just a, I mean, the way that an Indian shareholder would be considered as a beneficial owner for the company, in an Indian company which is listed in India. Similarly, for that company, if there's a foreign shareholder, then they would be considered as a depository holder for that particular company and may not be a beneficial owner for that matter, but the benefits are the same. You get called for meetings, you can vote, you can get dividends as and when declared. So basically all the rights of a member, but by virtue of holding a deposit receipt. Similarly, you have the concept of charges. Charge is an interest. It's a creation of an interest in a particular property. So if you think of lease or mortgage for that matter, all of these are something which can be created on immovable property, a house property for that matter. So you can mortgage that particular house property. Say for that matter, if you're talking about uh, a piece of land property. So you can lease it out or you can mortgage it for that matter to a bank and get some money. So the fact that you do all of this, you're creating an interest in favor of those entities. One being your bank, another being your, uh, any entity which is going to repay you that amount of money. So all of this is mentioned within your registration of charges where you create an interest. However, share is a movable property, and which is why you can only create an interest or a lien over that particular asset, which is your share. That's a movable property. So lien means it's a right to retain. Lien can be your general lien or particular lien, but lien never gives a, what do you say? Lien never gives a right for the person who enjoys that lien to sell that particular property unless it's mentioned within the particular act itself. So lien is something which has to be looked in very carefully. So you can create a charge over those sort of shares by having the charge of lien or you know any sort of interest. But also the fact that when you do that, the particular, what do you say, uh, uh, the shares that you are actually pledging, or there's actually a lien that is happening. Your pledging of shares, if you may have heard, that actually happens with respect to your promoter's shares. With respect to these sort of lien or these sort of charges that are created, that can be created in anybody's favor depending on whose shares are you creating that particular charge on, and what sort of rights do you think the person will get upon non-repayment of the amount of money in lieu of which the lien has been created. So this has been mentioned. There are two kinds of charges, floating charges or fixed charges, depending on what exactly is it that the company wants or how the company wants to go ahead with repayment of its loans or debts. The charges are then created accordingly. And they have to be registered with the registrar of companies. So this is the compliance with respect to the register of charges, what happens to the kind of charge that has been created or an interest that has been created over a particular property. All of these are basically compliance oriented, where they talk about registers as such. There is usually a share transfer agent of that particular company, which the position has become very redundant in these days because we have the CDSL and the NSDL, so the Central Depository Securities Limited, and then the National Securities Depository Limited. Now, when we talk about these depositories, they have their own, what do you say, depository participants who are also attached with them. And there can be companies who would like to register their shares for trading, etc., for updation, etc., for maintenance of registers with either of these depositories. So most PSUs have their depository as CDSL. So in such cases, the CDSL will be featured as a member for you as in your register of members, whereas you would be considered as a beneficial owner who's actually holding those shares in their own name. And finally, we have the concept of annual returns. What exactly do we understand by annual returns? This annual return is something that you as a company would have to file, and that's a statutory compliance that you have to do as a company, without which it is impossible for you to function in the company. So every single time that there is an annual general meeting, a board's report, which is affixed with the annual report, is fixed with annual returns that is also filed under Section 92. And this is something that is the duty of the director as such. So in such cases, in the annual return, what are you supposed to mention as a director? Every single thing, starting from your registered office to the principal business, any sort of, the details about your capital structure, if you had any holding, associate or subsidiary companies, shares, debentures, or other securities shareholding pattern, its indebtedness, members and debenture holders, along with changes therein. So all of these, then all of these basically something which you can mention with respect to your annual returns. In any case, all of these annual reports need to be registered with the ROC. Even though it's not a public document, the shareholders can very well ask for inspection of those documents, but only request those things to be provided for by the company, which is usually the case in every AGM. Barring that, this is a statutory compliance of the company to file annual returns. When we come down to meetings, what exactly do we know of meetings? When we talk about meetings, meetings are basically of two kinds, you can say, or multiple kinds if you talk about class, what do you say, uh, class shareholders or certain class of security holders, etc. When we are talking about meetings, we are usually talking indicating at either a general meeting or the second is a board meeting. So a general meeting is that of the members, whereas a board meeting is that of the directors. And there are certain compliances for it with respect to how many times are they statutorily compelled to meet in a year, in a financial year. Secondly, how many times are they supposed to, what do you say, register their resolution? Or how many days notice are you supposed to provide if you wanted to hold the meeting or in order to convene the meeting? What exactly needs to be written in those notices or agendas for that meeting? What exactly can be transacted? What sort of business can be transacted in that particular meeting, be it a general, be it a board meeting? What could be the venue for these meetings? So either it could be in the place of the registered office of a company, or it could be of any other place, whichever you feel you like to go on a vacation somewhere, say Maldives, etc., and then you wanted to have a board meeting over there, you could. But that's not something that you can do with respect to a general meeting, because general meeting mandatorily has to be held in the registered office of a particular company where these members are have been called for a meeting. But nowadays, since the video conferencing, etc., has come into play, and then there's always a technological development. So usually the voting, etc., of the meetings happen online, where they have all sorts of benefits. So they have linked with the depositories where they'll make an arrangement as to the fact that you can vote or who can vote in your place and all of that. Now, let's go into the discussion of meetings. Section 101. So you have 96, 100, and 101. All of these sections are basically which talk about a meeting. The very first thing, the fact that you need to have a meeting is something that the directors would feel the need for and eventually send out a notice. If it's an annual general meeting, you have to hold it at the designated time and place that you are supposed to hold. So it could be something that you have mentioned the last year, but you still need to mention it this year, even if there has been literally no change in the venue or the time or the place, etc., of that particular meeting to be held. But this is what the notice says. Section 101 that provides that a general meeting may be called by giving not less than 21 clear days notice. So this is something that is very important for you in order to follow, even if you're holding the meeting online. So it's not always physically that whenever you calling people, you need to give them some time in order to book tickets, etc., and come down. Even if it is online, you're supposed to give that 21 days notice. And this is something which is very mandatory statutorily, because if you don't follow this, your company or you as a director can be held liable for what do you say, oppression or mismanagement within a company. So shareholders can actually complain that this is so every single time that there is a secretarial audit in your company, they will ask you that in a secretarial audit of the company, what exactly is it that is recorded? All the compliance aspects, all the aspects wherein they say they ask, have you given the notice period of 21 days? Or have you mentioned all the agendas within that particular notice? Did people, did the persons who were supposed to come and vote in that particular meeting or participate in the business transaction, did they have enough time to think over it as to what they want to vote for? Or did they have enough time to prepare a proxy in their place to vote for them? So there are many things that as a particular company you need to be very vigilant about. And all of these things, because it's a company secretary's job, it all goes down as a matter of record. If you have not furnished the 21 clear days notice, or say if you have not uh, mentioned the business or the agenda that needs to be transacted on that particular date, then it's an invalid notice. Now, general meetings can also be called at a shorter notice. However, there is a mandate for it. So, in case of a annual general meeting, by not less than 95% of the members entitled to vote thereat, and in the case of any other general meeting, by members of the company holding majority or 95% of the shares, the paid up capital of the company, or if you have no share capital, then at least 95% of the members of that particular company with the total voting power that is exercisable in that meeting. So all of these people are the ones who are supposed to conduct the affairs in that particular company with respect to the waiver of what do you say, the meeting number of days, or say for that matter, if you are talking about the methods in which the invitation needs to be sent out for that meeting, etc. What could be the contents of this particular meeting? Now, a general meeting is usually for a shareholder, but always remember that in an annual general meeting, especially, a shareholder will be will be invited. But in addition to a shareholder, the other two entities who will have to be, in fact, who might attend or not, that's a different thing, but who will have to attend that particular meeting is the auditor as well as the directors. So general meeting can't go without any moderation, or even if there is a moderation, it can't be a person from the minority section the same way as the last group was. So in such cases, the way that the meeting is to be held, or the way that the people are to be invited, or who is to be invited, that is all mentioned within the contents of that particular notice. So if you see section 101, subsection 2, that is where they actually talk about all of these concepts. So people that you have to invite are multiple, as well as the remaining facts about how this meeting is to be held. The next is with respect to notice to whom to be issued. So the notice needs to be issued to every member of the company, legal representative of any deceased member, or the assignee of an insolvent member. The second is the auditor or auditors of the company, or every director of the company. So all of these people need to be invited for the meetings that are held by the company. So clearly, if you have not done anything with the shares of the deceased, even when it has been applied for that the person in what do you say, concerned in the company as a shareholder has actually passed away. So in such cases, you either get the legal representative of these people, or maybe an assignee if it's an insolvent member who chooses not to pay or is willingly not going to pay that amount. So this entire concept is that of your meetings. Now, notice by electronic mode. It is not always necessary that a postal address is always required in order to send out notice, usually for AGMs, EGMs, etc. If you ever have transacted in shares, you would actually find that they actually do it in those particular cases. What do you say? Uh, Electronic mode in those particular cases where it is not possible for either of the members to attend. So in such cases, if you are sending a notice by electronic mode, that particular notice will be treated equally, the same way as every other notice which is sent by the company to its shareholders to transact very important business. The next is the format of a notice. What exactly is it that you need to mention within a notice? And what exactly do we understand by a special business that needs to be conducted by the directors? So you have section 102, subsection 2, which provides for all the purposes in case of an AGM and all business that could be transacted within that particular meeting. So these are the ones that you have to be very clear about. Then you have inspection of documents, which has been spoken about under investigation, inspection, and inquiry. Quorum for meetings is very important, which talks about what is the minimum number of people that must be present within a particular meeting or within a particular 6 months, etc., for which the entire uh, meeting cannot be held if it's short of it. So you have to have a particular meeting with a particular number of members, and if you don't have that, the problem is that the meeting will not be held. And even if it is held, the resolution so passed will absolutely be void unless it is by circulation ratified by most members. So this is basically the quorum. This you'll find in section 103. Companies may have chairman, companies may not always have chairman, but for meetings, there's always a chairman who's appointed by the company, and that particular chairman could be anybody from within that particular board of directors presiding over that meeting. So, chairman of the meeting could be anybody who's literally going to, what do you say, decide if there is a certain issue that needs to be put to poll. So, if they think that no, there's no poll that is required for a particular issue, in such cases, the particular meeting will not extend. But if there is a substantial problem with the particular notice that needs to be sent out, then in that case, this concept would trigger in with respect to section 104. Who exactly is going to be the uh, chairman of that particular meeting? Similarly, proxies who vote in your name according to what you may have asked them to vote, whether it be in favor or against, but they are the ones who literally vote. And proxies can also have to be considered by the company because a fellow member has in fact chosen that particular proxy to act on its behalf. So in most jurisdiction that's possible, but in some jurisdiction they insist on having the member itself who's complaining of the entire shortcoming of that particular meeting. Inspection of instrument of proxy and representation of president governors in meeting. Representation of corporations at meetings of companies and creditors and restrictions on voting rights, a method of voting for that matter. So all of these are incidental to the whole concept of meeting and what exactly goes down in a particular meeting with respect to how voting needs to be done, how people need to be called, what are the standards for conducting that meeting. So we have secretarial standards also. It will be beneficial for you to know that this particular secretarial standard that we are talking about, that basically is maintained by the company secretaries who see whether or not the entire, what do you say, the entire meeting is happening as per the mandated norms or the circular. Because if that doesn't happen, then they might be held liable for secretary during secretarial audit, and then it will spell doom for the company as such. There are various ways of voting, whether you show your hands or through electronic means or by poll or a postal ballot, depending on whatever. If you know about parliament, in parliament, there's Rajya Sabha where uh, the deputy president, the vice president rather, he's the one who's actually the chairperson. And then he puts certain resolutions to vote at the end of every meeting. So they are so insignificant that nobody really cares. But there can be certain situations where a person may be, what do you say, uh, certain difficulties and not maybe even after no difficulties, the fact that a person would choose its cost accountant or a chartered accountant to go attend the meeting, that is something that is envisaged. So let's move forward with second. So in such cases, let's go into the concepts of resolution. Resolutions could resolutions are your section 114 subsection 1, which provides that a resolution shall be ordinary resolution if the notice required has been duly given and it is required to be passed by the votes cast, whether on a show of hands or electronically or on poll, in favor of the resolution, including the casting vote, if any, of the chairman by members who, being entitled so to do, vote in person or where proxies are allowed, by proxy or by postal ballot, exceeds a vote, if any, cast against the resolution by members so entitled and voting. So, when you talk about resolutions, there's ordinary resolution, which is 50% of the strength, whereas special resolution is a place where you require a certain number to be achieved, whether it be three-fourths or say a special majority where you require, say, 80% of the people to vote. So, absolutely, whatever has been duly specified in the notice calling for that particular meeting, none of the resolution would actually stand. Now, special resolution, there'll be multiple points regarding it. Resolutions requiring special notice, resolutions passed at an adjourned meeting, and resolutions and agreements to be fined. Resolutions and agreements that need to be filed. Any resolution of the board of directors or agreement executed by the company relating to the appointment, reappointment, or renewal of the appointment or variation of the terms of appointment of a managing director. All of these can actually be affixed with that particular resolution. So you have the way to vote either through postal ballot, that's also mentioned, or through electronic means. Now, how do you conduct an annual general meeting? Whenever we talk about an annual general meeting, it's basically a statutory compliance. Statutory compliance is a compliance under which the, what do you say, uh, which is something that a company has to perform, without which you cannot have run a company for that matter. So an AGM is an annual general meeting which has been spoken about with respect to a particular. Okay, there's a question regarding, can you whether you want to adjourn a meeting? Is that what you are talking about, Raman, or whether you can adjourn a resolution? Because I don't know about the concept of adjournment of any resolutions as such, but there can be a adjournment of meeting as such. So when we are talking about adjournment of meetings, that can be done. But for that matter, a resolution need not be passed with that particular annual general meeting. It's only when, say, supposing if there's no proper quorum in a general meeting, an annual general meeting, then clearly you have to adjourn it. There's no other option. But if you have a proper quorum in that particular meeting, but say supposing if there is no proper notice that has been sent, or if there is no proper what do you say, agenda that has been affixed for discussion in that particular meeting. Only under these very extraneous circumstances, when there's a quorum, then the directors may resolve to adjourn the meeting. But other than that, there's no adjournment, a valid adjournment of an AGM that can really happen, because AGM is one statutory meeting, which is very important for the company, for a company to even maintain its validity. Because without an AGM, you cannot retain validly your what do you say, status as a company, because you'll clearly be in default, and then there'll be a problem with respect to transparency issues and disclosure issues with respect to your shareholders. So clearly you do not want all of that for your company, so you will conduct your AGM, and it is at the AGM that you need to publish your annual report, which encompasses your board's report and your audit report, audited financial statements of the company, which the shareholders need to see. If you don't have these, then it becomes a bit of a problem. So your company may suffer litigations at the hands of the shareholders if you default in any of it. So any other meeting other than the annual general meeting is considered as an EOGM. It's an extraordinary general meeting which can be called from time to time by the company for its shareholders if there's some sort of an urgent, what do you say, business that needs to be transacted. Supposing if dividends need to be given out and you have not discussed it in your AGM, or say if directors' remuneration needs to be increased and that didn't happen with respect in your annual general meeting. So in such cases, your extraordinary general meeting would be a particular place where you would be discussing these. And that also is supported by the whole compliance aspect of notice and various other compliances that you need to do under Section 100 and so on and so forth. Right. So this brings us to one of the most important discussions of Companies Act, which deals with your management. Management is a concept which deals with your corporate governance principles. So you have the principles of corporate governance, which talk about the various theories. So you have an insider model, you have an outsider model. Insider model is basically where you have majority of your shareholders or majority of the shares of your company are held by a certain family or insiders of one particular family, whereas I mean it's a family what do you say, family owned business sort of a model, whereas an outsider model is where most of the shareholding of your company has been diversified amongst various shareholders, and they can be your, what do you say, qualified institutional buyers, they can be your what do you say, uh, your mutual fund companies, or different other shareholders, whoever basically, who are not a part of the family which is possibly started. So if Ambani's family holds the majority shares in that particular company, Reliance, then in that case, that's a family-owned business, even though you have majority, you have a lot of shareholding which is being held by outsiders who are non-members of that particular family. Now, when we are talking about corporate governance theories, they basically say that there are three basic theories of corporate governance. One is your agency theory, the other one is your trusteeship theory, and the third one is your stewardship theory. Agency theory, although traditionally we know that in a company, agency means your directors. Because a company, even though being a separate legal personality, does not have hands or limbs, and which is why the particular company has to be, what do you say? The company needs to be run, or the company needs to sign various documents. Then who's going to do it on behalf of the company? It is going to be the director. So every single contract that a director is going to enter into on behalf of the company is going to bind the company the same way as though the company had entered into the contract by itself, considering if it had hands of its own. But this is not the agency theory of corporate governance that we're going to talk about right now. Agency theory of corporate governance mentions that in a company, shareholders are the ones who contribute to the capital of the company. And because it is impossible or very inconvenient for shareholders to come down to manage the company at every time. So, in such cases, what do? They get people to represent their interests in the company, whereby these people can look after their money and their investments within the company and outside, and can be accountable to these shareholders. And these are your directors. So, principals over here are the shareholders who now have your directors as agents, and these directors are accountable to the principals, which are shareholders who have even nominated them and appointed them to the board, and thereafter are held accountable to these shareholders. This agency theory comes with a bit of a problem where we talk about the agency problem, where there can be a potential mistrust between the shareholders and the directors. And if there's a mistrust, then in such cases, the shareholders need to do something about it. So if I don't trust you with my money, then I think that you may embezzle my money, or you might want to, expropriate my money or steal my money in the company. What do? I get people to uh, look after or oversee or have a scrutiny on you. So in such cases, I might have independent directors or auditors for that matter, whose salary I'll be paying, but they are the ones who are going to look at the fact whether or not what you're doing with my money is just, or if it amounts to some sort of fraudulent behavior. So in such cases, when we are talking about a company as such, there are multiple of these concepts that we need to think about. Agency theory, agency costs, agency problems, these, the amount of money that you possibly would be paying to your auditors or independent directors as salary would be your agency cost. So as a company, you have to bear all of that, because you have this element of mistrust with respect to the agents that you have appointed, which are your directors. Now, this is mm, the whole concept of corporate governance as such, which goes on within a particular company. But when we are talking about management in a company, that begins with the premise of the fact that there is always something at the helm of the company, which is your board of directors. Primarily, a the board of directors in a company has been instituted or established so that the company can be run in a prudent way. Not every shareholder of a company would have the expertise in the business that the company conducts, which is why we appoint directors also who will have the expertise or the knowledge as to how the business of the company needs to be conducted, and thereafter would spend 2 cents of their expertise or their time or resources, etc., to guide the company into better profit making paths. So as a company, whether your company has a chairman, doesn't have a chairman, your company definitely can never exist without the board of directors. So this board of directors that you have in a company is one such board who runs the company for that matter. And they are the ones who are eligible to run the business of the company. So if the shareholders are the ones who are nominated them, appointed them, they're not happy with the directors, they can very well ask the directors to leave. So vacating the office of a director can also happen by the shareholders. Every single thing that you can think of with respect to what a shareholder can do with respect to a director can happen. Now, whenever we talk about this concept of directors, the very first thing is who is a director? Who can be a director? Now, to be very honest, the Companies Act as such does not mandate as to which any in any other sections basically as to what is the definition of a director. But a director has been, even though they have not been defined as a director, as a director in the board of directors of the company, that's the definition in the Companies Act. They have not been defined as such. What exactly is it? What is the duty, or what are the what are the things that a director is empowered or not empowered to do? They or the minimum qualification. They only talk about one thing, which is under what situations can a director not be disqualified. So if you see the way the act has actually been designed, the Companies Act 2013 has been designed with respect to this particular chapter. They wanted to give full autonomy. They wanted to give full liberty to the companies as such to exercise their own wishes with respect to whom they want to choose as directors. So there's no stipulation that you have to be a matriculate or say a postgraduate or a PhD holder in order to be a director of a company. There's nothing of that sort. So long as you are eligible to contract and are not disqualified under Section 149, you are good to go. Which basically means that you will be able to get a director's identification number. And the moment you get a DIN, that will enable you either to become a full-time director of a company, or say a nominee director of a company, or say for that matter, your uh, independent director of a company. Which would also be dependent on the fact with respect to other qualifications which are mentioned within the company's articles of association, but nonetheless. So this whole concept of who can be a director or what exactly is a director or when can a director be removed or be disqualified as such, they're all mentioned from here on now. So this is what we are going to discuss with respect to a director, and we are going to discuss about the remuneration of the director in addition to all of that. Because at the end of the day, director is working hard for your company, and most times shareholders may not be the directors of the company. So in such cases, the fact that you are in fact taking the time to function as a director of the company just so that the company can be moved towards profit making motives. That is the whole idea with respect to a particular director. So in such cases, even though you are not a shareholder, you can still exist as a director. And in such cases, you'll have a contract with the company that will govern how you behave in the company, whether it be with respect to your rights or your duties. So we are going to discuss this. I'll just take a 10-minute break and then we can resume discussing this. All right. Okay, we can begin with directors now. With respect to director's role or responsibility in a particular company, the idea is that who exactly do we consider as directors? There are ones in the management of the company, and the fact that a director is basically a member of the board of directors in a particular company. Now, how do we understand the roles and the responsibilities of a director? His disqualifications, there's no such qualification as such, or appointments or retirements, and everything that is incidental to what a director does. So, when we are talking about a director, one of the first and foremost things that we have to talk about is with respect to uh, your responsibilities. Section 166 of the Companies Act basically talks about the duties and the liabilities that have been imposed upon a director. If you see, it's very wide the way it has been mentioned. Act in good faith, you shall exercise your independent judgment, shouldn't have any conflict with the interests of the company, or you are never supposed to make any unlawful or wrongful gains from the company, or take any advantage or undue gains from the company, or unjustly enriched from the company. And you're not supposed to assign your office to anybody. So clearly, as a director, you have been appointed to work in order to run the company. So if you assign your office, transfer your office to somebody else, or choose your proxy, then it defeats the purpose of choosing you as a director, because you've been chosen for the fact that you have the expertise. You're not the representative of a certain corporate body. So a company, a legal person